All right, so this is part 2 of the as-is contract. Last week we went all the way up to line 124 where we were talking about financing and what that looked like for the buyer, what that commitment looked like for the buyer. And so we're going to start at closing costs, fees, and charges. So please make sure that you go back and see the recording from last week. If you missed the first part, that's okay, don't worry. That's part of the benefit of everything being on a recorded in the cloud, so we'll be able to share that out. And so I'm going to move through. This is going to be not as much of a line by line on this half of the as-is contract, because a lot of it is just, quite frankly, already written out for you. So I really want to go through some of those things that are here. So as you can see in the as-is contract, paragraph 9 is talking about closing costs, title insurance, survey, home warranty, special assessment, what's to be paid by the seller and what's to be paid by the buyer. So notice that it says doc stamps are to be paid by the seller, HOA, estoppel fee, the owner's policy, a recording of any other fees, seller's attorney fees, the title search charges, any kind of municipal lien search, right? And then it says, if prior to closing, seller is unable to meet the as-is maintenance requirement, it says shall be escrowed a total, as per paragraph 11, a sum equal to 125% of the estimated cost to meet those requirements shall be escrowed at closing. If the actual cost is to meet the as-is requirement exceeds the escrow amount, then the seller shall pay such actual cost. Any unused portion of escrow amounts shall be returned to seller. Cost to be paid by buyer is taxes and recording fees of any of the new stuff. So basically think that the seller is to pay for everything leading up to the sale of the property. I'm proving to you that everything has been paid. There is nothing that is owed. I do have the right to sell this property. No one else has a claim to the title. Municipality doesn't have any searches. So I'm going to pay to make sure that the title company can do that search, provide those figures, and make sure that I do in fact have the ability to sell this house free and clear. If for whatever reason there is some maintenance requirement, then that of course is where it's talking about it being held in escrow in the amount of 125% of that estimated cost. It is rare, but it does happen. So that's where you just need to know about that. More often than not, everything is going to be taken care of prior to closing or at closing, and there won't be any reason to have an escrow hold back. Now for the buyer is paying for anything to record moving forward, right? So the taxes and recording fees on the notes and mortgages, any kind of recording fees and financing statements, the owner policy, if paragraph 9C part 2, so you'll see down here, if part 2 is checked, then they would pay for the owner policy. The buyer's is to pay for a survey. The buyer's to pay for the lender's title policy and endorsements, any application or transfer fees, any search again if part 2 is checked, any loan expenses, appraisal fees, buyer inspections, buyer attorney fees, all property related insurance, and the owner's policy if part 3 is checked. So notice here that it's talking about title, evidence, and insurance. So go ahead and read this on your own time. You'll want to come back to that. Line 157, right? So 158 or 162 is whether or not the seller shall designate the closing agent and pay for the owner's policy, or if the buyer shall designate the closing agent and pay the owner's policy. Typically, it is the seller who is going to designate the closing agent and pay the owner's policy and charges. That's pretty common here in the area. You will see some investors, or if someone wants to use their particular real estate attorney, they might opt to check the second box here, of which is going to be slightly more expensive on the buyer because they're incurring some of those costs. And then part 3 on line 164 is really only applicable to Miami-Dade, the Broward area. So that would be your Miami-Dade area. Survey on line 170, notice that it says on or before the title evidence deadline, right? So if we look at here, subsection D is talking about title evidence and insurance. If left blank, then 15 days, or if paragraph 8A is checked, then 5 days prior to closing, right? So if left blank, then 15 days prior to the closing date. So what this is saying is that your buyer should order a survey well in advance so that they can review and see if there's any encroachments on the property, if there's any disputes on a fence, if the fence is on someone else's property. You want to know all that information prior to those 15 days prior to closing. If, for whatever reason, that survey is presented, let's say 10 days before closing, and you notice that there's an encroachment and your buyer is not happy about it, it is too late. They cannot cancel just because of the survey because they didn't do it on or before the title evidence deadline. So you really want to make sure that that is ordered ahead of time. You want to see, does the seller already have a copy of the survey that's a recent survey, right? So it says, if the seller has a survey covering the real estate property, a copy shall be furnished to the buyer and closing costs within 5 days after the effective date. If not, then your buyer will pay the cost of getting a survey done. Line 173 is whether or not a home warranty is to be paid. This says, at closing, buyer, seller, or non-applicable shall pay for a home warranty plan issued by blank, not to exceed blank. Typically, this is only going to be a part of the contract if the buyer is requesting for the seller to pay for the home warranty. If the buyer is already paying on their own expense and it has nothing to do with the actual contract for home warranty, it's really not here. This would be if your buyer is asking the seller to pay for a home warranty, of which then you can either say it's going to be by a particular company if you already have a relationship with like a 210 home warranty or an American Home Shield. If your buyer does not have one decided at the time of the contract, then you can always put a to be determined and not to exceed a cost of $425 or $600. It's pretty common if it's it's a standard house, there's not a pool, there's not a whole lot that would be outside of the norm, that you can find coverage of a home warranty for under $500. So that would be here for home warranty. Again, at closing, this would be where we would potentially check the seller shall pay, and then to be determined, or if you already have your company, not to exceed blank. Special assessments. At closing, the seller shall pay either one, the full amount of liens imposed by a public body, which does not include a condominium or homeowners association, that are certified, confirmed, and ratified before closing, and two, the amount of the public body's most recent estimate or assessment for an improved which is substantially complete as of effective date, but that has not resulted in a lien being imposed on the property before closing. Buyer shall pay all other assessments if the special assessment is to be paid in installments. So notice that you have two options. Line 183 says that the seller shall pay installments due prior to the closing, and buyer shall pay installments due after the closing. Installment prepaid or due for the year of closing shall be prorated. And then line 185 asks for the seller shall pay the assessments in full to or at the time of closing. So a lot of people ask, well, which one should I do? It really depends. It's a conversation with your buyer on what they want to do. Typically, if you think of this, for me personally, the way that I like to explain it to my buyers is, let's say that there's a brand new road, right? They just repaved the parking lot. Well, is the seller enjoying the repaved road, or is the buyer enjoying the repaved road? Well, the buyer is going to enjoy a majority of the life of that repaved road. And so the seller shall pay the installments up to the closing, and then the buyer shall pay after that, right? That to me makes sense. And it's up to your buyer on what makes sense to them. I'm only giving you an example of how to explain it. Now, if the seller is trying to say that my condo is worth $40,000 more because of brand new windows, and that seller is trying to include that new windows treatment, or new windows rather, into the purchase price, then you can't also give my buyer the bill for the installments for those windows, right? And so if it's to be included in the price, then the seller shall pay that assessment in full, right? If you're trying to roll that in as part of a perk of the unit, then to me, if you're rolling that into the sales price, then you are to pay for all of that since you're planning on reaping the benefits of it, right? Does that make sense in terms of special assessments on installments? Thank you, Nikolai. Okay. So then we talk about disclosures, right? So I'm not going to go over the disclosures with you. This is saying the types of disclosures that people can do, right? They can do a radon gas exposure. They can do a permits disclosure, a mold disclosure. They can do a flood zone elevation certification, right? So you will see that there is an asterisk here. So it is saying that if property is in a special flood zone area or Coastal Barrier Resources Act designated area or otherwise protected area identified by the U.S. Fish and Wildlife Service under the Coastal Barrier Resources Act, and the lowest floor elevation for the buildings and or flood insurance rating purposes below minimum flood elevation or is ineligible for flood insurance coverage, may through the National Flood Insurance Program or private flood insurance as defined in 42 U.S. Congress subsection 4012A, then the buyer may terminate this contract by delivering written notice within, if left blank, then 20 days after the effective date. So I just want to pause for a moment. As you can see, there's so many critical dates that are moving through the contract. This is why we do not put on or before for the closing date. On or before means that it's a moving target. Well, is it 20 days before what? On or before? Is it 15 days prior to closing? On or before when, right? That's why we want to have a really concrete closing date, because all of our critical dates that work prior to closing are going to be affected by that, right? So we want to be very intentional. You can give the energy brochure, right? So these are saying ones that can be used. If the property includes or a pre-1978 residential housing, right? Because remember, in real estate, we sell the property and the improvements thereon. So if some of the improvements on the land includes a pre-1978 residential housing, which means 1977 or before, a lead-based paint disclosure is mandatory. Okay? Line 221, I want you to read that. It's all in bold, right? It says homeowners association or community disclosure. So if you have a client who's purchasing a home in an HOA community, it says buyer should not execute this contract until buyer has received and read the homeowners association or community disclosure. Buyer should not execute this contract. So we don't get under contract and then your client reviews the HOA docs and sees that they can't fly their favorite sports team flag in the neighborhood, or they can't have a Harley Davidson, or they can't drive any kind of work truck in the neighborhood, and they're already under contract. This is where we want to review those materials before we sign the executed contract. Property tax disclosure summary, right? Buyer should not rely on the seller's current property taxes as the amount of property taxes that the buyer may be obligated to pay in the years subsequent to purchase. A change of ownership or property improvements triggers reassessment of the property, right? So if you have someone who is a first-time home buyer and they're looking to purchase a property and it was owned by the same lady for 40 years and she sold it 9 months ago to a flipper who completely flipped the property, everything about it is new, it will be reassessed. It will not be on the fact that she was locked in during Save Our Homes because she was homesteading and she didn't do anything to it. So please do not tell your client, oh yeah, look, taxes are only $800 a year. Isn't that fantastic? It was fantastic for her when she lived there for the last 40 years. It doesn't mean it's going to be fantastic for you. So please understanding that improvements trigger reassessment of the property, and that can result in higher property taxes. If they have any questions about concerning valuation, they need to contact the property appraiser's office for more information. FIRPTA, right? So the seller shall inform the buyer if the seller is a foreign person as defined by the Foreign Investment in Real Property Tax Act, known as FIRPTA, right? So buyer and seller shall comply with FIRPTA, right? If that's the case, then money needs to be held back. If your buyer is a resident of the United States and intends to use the property as their primary resident for a minimum of 2 years, then it can actually waive the requirements of FIRPTA, right? So if they're buying the property from, let's say, a Canadian who has owned the property for a while, your buyers intend to live in the home as their primary residence for the next 2 years, then it will actually have the ability to waive the FIRPTA requirement. But you can talk to your title company to know more about FIRPTA if you'd like to. Seller's disclosure. So the seller property disclosure, the actual form, is not a required disclosure. We do have a seller's property disclosure for your convenience and for your seller's convenience, because line 238 says the seller knows of no facts materially affecting the value of the real property which are not readily observable and which have not been disclosed to buyer, except as provided for in the preceding sentence, right? Seller extends and intends no warranty and makes no representation of any type, either express or implied, as to the physical condition or history of the property, except as otherwise disclosed in writing. The seller has received no written or verbal notice from any government entity or agency as to a currently uncorrected building, environmental, or safety code violation. So the seller's property disclosure is a way to let people know about it in one unique place. As a seller must disclose any of that information. Again, understanding that the as-is contract was founded during the time of the recession when banks owned a lot of property. They had no idea of the condition of the home. It became an asset that they were given back. It really was a liability at that point, and so they were trying to offset those assets. So the as-is contract should only be used when buying something where the buyer knows that they're going to buy it no matter what the condition, or if an investor is coming in and purchasing the property. We really want to be using the standard FAR/BAR contract, which we will be going over at a later date, but I want you to know and be familiar with the as-is contract since many people use that. There are still a lot of flippers that are out there, although they're becoming less and less because of the fact that inventory is so low and prices, I'm hearing almost every single time, if a buyer is looking to put in an offer, there's multiple offer situations, people are paying over asking, they're using an escalation clause. A lot of these things are getting involved. So an investor is not really able to come in if something is on the market and buy it below market value. It's just being really difficult to do that. Paragraph 11 talks about property maintenance, condition, inspections, and examinations. So except for ordinary wear and tear and casualty loss, seller shall maintain the property, including but not limited to lawn, shrubbery, and pool in the condition, in the condition existing as of the effective date, right? So as soon as we sign the contract, then minus just ordinary wear and tear, the seller is still required to maintain the lawn, shrubbery, the pool, the condition of the home. Property inspection. So this is part of the reason why people think that they need to use an as-is contract, because during the inspection period, a buyer can cancel for pretty much any reason, even for sniffing a ghost. So there is a right to inspect addendum that can be used on the standard contract that's going to have a lot of the same language, just an FYI. But we really want to help a buyer find a home and want to buy a home. We don't want a buyer just to write a contract, cancel a contract, write a contract, cancel a contract just because. However, the language in paragraph 12 says, buyer shall have, if left blank, then 15 days after effective date. There's really no reason that you need 15 days for an inspection period, especially today. If you want your buyer's contract to be, or your buyer's offer to be competitive, a 15-day inspection period, especially on a home that just went on the market yesterday or a couple days ago, is not really a good idea, just FYI. Especially if you're just doing a general inspection, right? You're just going to have one inspection. You're going to have an inspector come in, general inspector. You're going to have a mold inspector. You're going to have a structural engineer come in. You're going to have a pool guy come in. Okay, maybe you're going to need a little bit more time. But I would advise that you reach out to your home inspector company if you're going to do a general inspector and ask them, hey, we're thinking about putting an offer on this property. When would you be able to go in? Do you have any availability this weekend or early next week? Okay, well, now that I know, I can then plan accordingly. However, it says buyer shall have, if left blank, then 15 days after effective date, known as the inspection period, within which to have such inspections of the property performed as buyer shall desire during the inspection period. If buyer determines, in buyer's sole discretion, that the property is not acceptable to buyer, then the buyer may terminate this contract by delivering written notice of such election to seller prior to the expiration of the inspection period. If buyer timely terminates this contract, then the deposit paid shall be returned to buyer. Thereupon, buyer and seller shall be released of all further obligations under this contract. However, buyer shall be responsible for prompt payment for such inspections for repair of damage to and restoration of the property resulting from such inspections, and shall provide seller with paid receipts of all work done on the property. Meaning, if you have an inspector that comes in who's going to drill a hole into my original hardwood floor so that they can put a scope cam down the hardwood floor, and you don't buy that house, then you have to pay to replace the damage that you put that hole in the floor, right? So being very clear of what the inspector is going to do, and that unless you've been given explicit permission, you got to be very careful about that, right? Unless buyer exercises the right to terminate granted herein, then the buyer accepts the physical condition of the property and any violation of governmental, building, environmental, and safety codes, restrictions, or requirements, but subject to seller's continuing as-is maintenance requirement, and buyer shall be responsible for any and all repairs and improvements required by buyer's lender. Right? Walk through, inspection, and reinspection. So here's what this looks like. If during the inspection period your inspector finds something on the home, right? Let's say that it requires a plumber to come in and do work. It requires an electrician to come in and do work. It requires something that is not cosmetic. Please make sure that you have if it requires a licensed professional, then please make sure that a licensed professional is going to come back out, whether it's a general inspector or it's a specialist in that particular field, to come back and reinspect prior to closing, right? Like if you can't see it with your eyes, if you have no idea, hire a professional, right? So for instance, selling a home that has knob and tube, I have no idea whether or not it's been replaced or whether or not it was safely disposed of, or whether or not, even though it's still in the house, but it was disconnected, so it's not a thread anymore. I don't know what that looks like. I'm going to hire an electrician, and I'm going to make sure that the electrician comes out and does a reinspection. Your inspection company, like Rock Solid, Deanne's on here, right? They will absolutely do a reinspection. The reinspection, I mean, she will tell you what their rate is. Every inspector is going to be different. They're not going to charge you a full home inspection. Again, if they're coming back out and just looking at a punch list, right? Just the 2 or 3 items that maybe were a part of the request for repairs. So understanding, however, on the date prior to the closing date or on closing date prior to the time of closing, as specified by buyer or buyer's representative may perform a walkthrough and follow-up walkthrough if necessary, inspection of the property solely to confirm that all of the items of personal property are on the property, and to verify that the seller has maintained the property as required by the as-is maintenance requirement and has met all other contractual obligations, right? You must do a walkthrough prior to the closing, which also means seller needs to make sure that the house is ready to be inspected, right? The seller can't have furniture in the house leading all the way up to closing. It needs to be removed. The seller assistance and cooperation and closeout of building permits. If the buyer's inspection of the property identifies that there are open or needing building permits, then the seller shall promptly deliver to buyer all plans, written documentation, or any other information in seller's possession, knowledge, or control relating to the improvements of the property, which are the subject of such open or needed permits, and shall promptly cooperate in good faith with the buyer's efforts to obtain estimates of repairs or other work necessary to resolve such permit issues. Seller's obligation to cooperate shall include seller's execution of necessary authorizations, consents, or other documents necessary for the buyer to conduct inspections and have estimates of such repairs or work prepared, but in fulfilling such obligation, seller shall not be required to expend or become obligated to expend any money. And it says the assignment of repair and treatment contracts and warranties at buyer's option and cost. Seller will, at closing, assign all assignable repair, treatment, and maintenance contracts and warranties to buyer. So if I had the house tinted and the termite company has a transferable warranty, but there is a cost associated to the transferable warranty. Line 277 says who's going to pay for that transfer, the buyer or the seller? Bueller? There is a transferable warranty and there is a cost associated with transferring that warranty. Who is to pay that transfer? Buyer or seller, as per line 277 through 279. Thank you, John. I don't know where everyone went. That one was not a hard one. Yeah, buyer is to pay the cost, right? Okay, escrow agent, which is also different than closing agent. However, escrow agent is going to be either the closing agent or escrow agent, collectively known as agent, who is receiving the deposit, other funds, and other items, is authorized and agrees by acceptance of them to deposit them promptly, hold same in escrow within the state of Florida, and, subject to collection, disperse them in accordance with terms and conditions of this contract. Failure of funds to become collected shall not excuse buyer's performance. When conflicting demands for the deposit are received or agent has a good faith doubt as to entitlement to the deposit, then the agent may take such actions permitted by paragraph 13 as agent deems advisable. If in doubt as to agent's duties or liabilities under this contract, agent may, at agent's option, continue to hold the subject matter of the escrow until the parties agree to its disbursement or until a final judgment of a court of competent jurisdiction shall determine the rights of the party. Or agent may deposit same with the clerk of the circuit court having jurisdiction of the dispute. So pause there. If for whatever reason escrow is to be disputed or contract is to be canceled, there is an addendum that is called the release and cancel, right? Which is actually two options, right? So the cancel of contract. So contracts don't expire. They're either executed, extended, or canceled. So understanding that the release and cancel document is actually two parts. So the cancellation of contract is going to be unilateral. Buyer and or seller, all they need to do is one side needs to deliver the intent to cancel, right? That can be one or the other. The release of escrow, the release of funds, must be agreed upon and signed, so it's bilateral. Both buyer and seller need to agree that they're releasing escrow and that escrow is going to be given to either buyer or seller. If for whatever reason buyer and seller cannot agree to where escrow is going to go, then the escrow agent is to hold on to that money or turn that money over to the clerk of circuit court until a judgment has been filed through mediation, arbitration, or litigation. On line 290, an attorney who represents a party and also acts as agent may represent such party in such action. Upon notifying all parties concerned of such action, all liability on the part of agent shall fully terminate, except to the extent of accounting for any items previously delivered out of escrow. If a licensed real estate broker, agent will comply with provisions of Chapter 475 of Florida statute as amended and the Florida Real Estate Commission rules to timely resolve escrow disputes through mediation, arbitration, interpleader, or an escrow disbursement order. Okay, remember, FREC gets to make that decision. This is why it's so important that you read this, right? I'm going line by line through this with you. I'm not writing anything, but it is to make sure that you are familiar with the language that is here and remembering the process of what needs to happen in terms of notifying FREC about an escrow dispute, that no one has made a decision, how you intend to move through, and make sure that buyer, seller, whether we're moving through arbitration or mediation, in any proceedings between buyer and seller where an agent is made a party because of acting as agent hereunder, or in any proceedings where agent interpleads the subject matter of the then agent shall recover reasonable attorney's fees and costs incurred to be paid pursuant to court order out of the escrowed funds or equivalent. Agent shall not be liable to any party or persons for misdelivery of any escrowed items, unless such misdelivery is due to agent's willful breach of this contract or agent's gross negligence. This, paragraph 13, shall survive closing and or termination of this contract. Now remember, all of paragraph 13 is not talking about you as the agent. It's not talking about the buyer's agent as the agent. It's talking about the person who's holding escrow, that third party. Paragraph 14, you can read on your own. Default and dispute resolution, you can also read on your own. In terms of dispute resolution, right, unsolved controversies, claims, and other matters in question between buyer and seller arising out of or relating to this contract or its breach, enforcement, or interpretation, also known as a dispute, as it will be claimed for this paragraph, will be settled as follows, right? Remember this from How Not to Go to Jail School. Buyer and seller will have 10 days after the date conflicting demands for the deposit are made to attempt to resolve such dispute, of which failing which buyer and seller shall submit such dispute to mediation under paragraph 16b. Buyer and seller shall attempt to settle disputes in an amicable manner through mediation pursuant to Florida rules for certified and court-appointed mediators in Chapter 44 of the Florida statute as amended the mediation rules. The mediator must be certified or must have experience in the real estate industry. Injunctive relief may be sought without first complying with paragraph 16b. Disputes not settled pursuant to this paragraph 16 may be resolved by instituting action in the appropriate court having jurisdiction of this matter. This paragraph 16 shall survive closing or termination of the contract. More about attorney's fees. And so then we're talking about standards of title, right? So you can read through this knowing about title evidence, restrictions, easements, limitations, understanding tax examination, or title examination, I'm sorry, what that looks like. Identifying the survey, right? So again, we can see in survey, I do want to go over this. So survey discloses encroachments on the real property or that improvements located thereon encroach on setback lines, easements, or lands of other, or violate any restrictions, covenants, or applicable governmental regulations described in Standard A, subsection 1A, B, or D above, then the buyer shall deliver written notice of such matters, together with a copy of the survey, to seller within 5 days after buyer's receipt of survey, but no later than closing. If buyer timely delivers such notice and survey to seller, such matter identified in the notice and survey shall constitute a title defect subject to cure obligations of Standard A above. If the seller has delivered a prior survey, seller shall, at buyer's request, execute an affidavit of no change to the real property since the preparation of such prior survey, to the extent the affirmations therein are true and correct. So again, what does this say about the buyer? That buyer shall deliver written notice in such matters, together with a copy of the survey, to seller within 5 days after the buyer's receipt of survey, but no later than the closing. Talking about ingress and egress, you remember when talking about water. Lease information, if there's any lease information that needs to be identified, you can read through that. If there are any liens, that must be furnished so that the buyer is aware of any of those liens. Understanding, we talked about this last Thursday, and I want to just recap on this because remember how to get away with murder. How Not to Go to Jail School was talking about time. More often than not, your instructor talked to you about business days. That is not the case. It depends on the contract. So with the standard FAR bar, the Florida Association of Realtor and the Bar Association, that's the standard contract. This is also the FAR bar as is contract. Doesn't actually identify time as business days, as we're going to read. So time, line 420, says that calendar days shall be used in computing time periods. Time is of the essence in this contract. Other than time for acceptance and effective date, as set forth in paragraph 3, the first part of the contract, any time periods provided for or dates specified in this contract, whether pre-printed, handwritten, typewritten, or inserted herein, which shall end or occur on a Saturday or Sunday or national legal holiday, shall extend to 5 p.m. on the next business day. All other time, just so that you know, is 11:59 of that day, right? Force majeure, as we understand, right, force of nature, what that looks like, please review paragraph G so that you understand, especially we have a named storm now out in the Caribbean, right, working its way towards Florida. So it's absolutely something to be aware of, especially if you're selling any time between June and October. We know that there are opportunities for hurricanes to come in. We know that that's something that can happen during our force majeure. Conveyances, so the seller shall convey marketable title to the real property by statutory warranty, trustees, personal representatives, or guardians' deeds as appropriate to the status of seller, subject only to matters described in Standard A and those accepted by buyer. Personal property shall, at request of buyer, be transferred by absolute bill of sale with warranty of title, subject only to such matters as may be provided for in this contract. We do not sell furniture, folks, just so that you know. We sell houses, we actually sell property and the improvements thereon. So if someone wants to do a bill of sale for property, right, if it's a furnished unit, you can help facilitate, but we are not going to make it a part of the contract. The value of the home does not matter about the mid-century couch that you have in the living room. That has nothing to do with the value of the home. So if they have a bill of sale, if buyer and seller agree to a transfer of furniture, go ahead and do that. If you're working with a seller and you know that their intention is to go ahead and sell it furnished, I actually have them log on an Excel spreadsheet or whatever. They actually are going to log and take inventory of all of the items that they're selling, but it has nothing to do with the contract, okay? Closing, location, documents, and procedures. It says the location closing will be conducted by an attorney or other closing agent designated by the party paying for the owner's policy of title insurance and will take place in the county where the real property is located at the office of the closing agent or at such other location agreed to by the parties. If there is no title insurance, seller shall designate closing agent. Closing may be conducted by mail, overnight courier, or electronic means. Closing documents, seller shall, at or prior to closing, execute and deliver, as applicable, deed, bill of sale, certificates of title, or other documents necessary to transfer title to the property, construction lien affidavits, anything else that might be necessary, right? The rest of this you can read through in terms of procedures, closing, disclosures. I want to make sure that I get through all of our pages together so you can go through and look at these things. Talks about 1031 exchange. Again, you can go through and read a lot of these things that are here, what that looks like. FIRPTA, so we were talking about this. Remember this from school. If a seller of U.S. real property is a foreign person, as defined by FIRPTA section 1445 of the IRS code, then it requires that the buyer of the real property to withhold up to 15% of the amount realized by the seller on the transfer and remit the withheld amount to the IRS unless an exemption to the required withholding applies or the seller has obtained a withhold certificate from the IRS authorizing a reduced amount of withholdings. Remember, just as I said, so if your person plans to occupy the space as their primary residence and they are a resident of the United States, they plan to use it as their primary residence for a minimum of 2 years, then it will actually waive the FIRPTA tax withholdings. Again, talk to your title agent. They'll be able to help you through those things, right? Okay, so then there are additional addenda that is required. So you will notice that there are addenda that, if it's applicable, you need to do. If you're submitting and you're having a contract signed and one of these boxes is checked, then that addendum has to be attached and signed by everybody as a portion of this contract, right? So it says that the following additional terms are included in the attached addenda or riders and is incorporated into this contract. So if it has a homeowners association, then we're going to use the homeowners association addendum. If you're using FHA or VA financing, you must use the FHA VA addendum. It's absolutely a requirement. If your intention is to use an appraisal contingency, right? So let's say that this is on a jumbo loan, it's on a loan that's going to have a 20% down, and you still want an appraisal contingency, then you would check addendum F, right? If there is anything else, so lead-based paint disclosure, right? That would be addendum P. If it's going to be in a neighborhood that is a 55 plus community or is going to be an additional housing for older persons, then you're going to check addendum Q, right? If you plan to do a backup contract, or if there's a kickout clause, or if it's contingent upon the sale of the buyer's property, again, we're going to check the appropriate addendum, and then we're going to attach that addendum to the contract. Additional terms. So if buyer and seller are agreeing to any additional terms, one of the most common that you're going to see in the additional terms is if the buyer is requesting the seller to pay a portion of the buyer's closing costs. So that language that would be in line 171 would be buyer and seller agree for seller to contribute 3% of the purchase price towards buyer's closing costs, prepaids, and or allowables, right? That would be the stuff that you're going to write. If for whatever reason you're intending to put additional terms, meaning you're going to pretend to be an attorney and you're going to use legal language and you're going to put it into the additional terms here and you're not quite sure what language to use, then please reach out to our broker resource, Murray Coleman. I, of course, will be a resource for you, but the point that I want you to know is that whenever you're working on a contract like this, you want to, before you seek help from just any agent in the office, think of it this way. If you were to be sued, is the person who's giving you advice, are they going to go with you during the hearing? And if your friend that's in the market center who kind of sort of remembers and is speaking from a place of authority is not someone who's going to go with you and share in some of those costs and sit with you during the hearing, then don't ask their opinion on the contract. We have a broker resource, Murray Coleman. He's there to answer it. I'm going to put his phone number in the chat box here in just a moment. He is on call. His sole purpose for us is to be on call and answer your questions via phone. So understanding that you have him, you also have your broker of record, Rachel Sartain, of which she is a busy woman and is our broker of record. That's why we've hired and retained Murray Coleman as our broker resource to answer those questions for you. So if ever you're worried about language, then please make sure that you pick up the phone and you ask him for the language that he recommends. Whatever his recommendation is, the brokerage stands behind that. Okay? And then when we submit it, then the seller can either counter the buyer's offer or the seller can reject the buyer's offer, right? On lines 158 and 191. It says this is intended to be a legally binding contract. If not fully understood, seek the advice of an attorney prior to signing. This form has been approved by the Florida Association of Realtors and the Florida Bar. And so we do need, you'll notice that on each one of these, there is initials on every page on the bottom. Your clients need to initial on every page, including the last page here. It is going to ask for their signature and the date. Signature date, if you're going to use DocuSign, it's automatically going to timestamp it for you. You do not need to worry about your buyer's address. You do need to put who the cooperating brokerage is and who the sales associate is. Same thing with listing and listing broker. And even though your client signed on page 12, it is still a requirement for them to initial on page 12. If for whatever reason any terms or condition are struck through by the buyer or seller, any edits are going to require all signatures based on that line. So for instance, if we go back to the top, let's say the purchase price, they say $350. That's what the buyer wants to offer is $350. The seller counters and says strike through $350, and then they write $355. All buyers and all sellers must initial somewhere around the changes that were made on the contract. Okay? All right. So we've got a little bit of time left. We don't need to fill up all 15 minutes if it's not a requirement. And I'm not going to go through the first part since it was already recorded. But does anyone have any questions on what we've gone through so far today? Okay, Nikolai, what's your question? Lender requires 4-point inspection for homeowners. There's no seller's disclosure. The home needs minor repairs. The suspense is killing me. And seller doesn't want to do them, okay? Do the repairs affect the 4-point? Okay. There is actually no such thing as a pass or fail for the 4-point inspection. There's no such thing. The 4-point is required in order to obtain insurance. However, there are insurance companies that you can go to that even if something is an issue that needs to be resolved in the 4-point, they will insure for 30 days after closing, of which then the buyer can have those repairs done and must satisfy those repairs within those 30 days to continue to have insurance. Now, if your buyer is not willing to make those repairs and the seller is not willing to make those repairs, well, then your buyer has to decide whether or not this is a home that they want to move forward with. If the answer is no, then they would have to go and find another home. All right. Okay. Any other questions or ahas? Did you learn something new today about the contract that you weren't aware of? Is it siesta time? Is it food time? Like, I got quite a few of you on here, and yet I'm not hearing from many of you. So Nikolai was talking about for the home warranty. Okay, awesome. John said, deep diving into the context reminds me of a contracts position that he had 10 years ago. Brian said he got here late and he's new. Where can I find the recording of step 1 in today's? So typically on the KW Chadwick Group YouTube channel, they have those recordings. I don't know if last Thursday has already been uploaded into YouTube. If not, then Brian, I can actually send you those recordings so that you can access them directly from Zoom. So I can send that to you after class. Absolutely. What are some ahas? What are some takeaways? What was something that maybe was either a reminder or it was something good to know or something that you plan to always remember when working with clients after what we've talked about? That the survey needs to be done in advance. Okay, awesome, Nikolai. John, plans to always inquire initially when unsure or to ensure that all signatures for execution. Okay, absolutely. Okay, well, if you have any other questions or concerns or ahas, go ahead and put them in the chat box for me. If not, thank you very much for your time. As always, we do this every Thursday at noon. It's a way for us to get together and mastermind, so I encourage you to have it on your calendar for Thursdays at noon to join me on Zoom, where we're going to have these conversations, discussions, ways for you to mastermind. That is very important. Nicole didn't know that as-is contracts aren't as common anymore. Now, they're still common because the agents who survived the recession are the successful agents of today. Many of them are the successful agents of today. And so it's just out of being creatures of habit and being lazy that they're the ones that are using it. However, it's very important for you to know the pros and cons of using the as-is contract and the standard contract, and then to be able to present that to your buyer so that your buyer can make the decision on whether or not they want to use an as-is contract or a standard contract, right? See, Nicole, you'll never, ever forget about the word that. Isn't that funny? All right, folks, have a wonderful afternoon. We'll see you tomorrow morning for the Reedy and Red Show. We have Ignite tomorrow from 9 until noon. And then we have the Ritz-Carlton Customer Service Experience class that is going to be from 1 to 3 tomorrow. So it is a very packed day, at least for me, if you're not going to attend all of those. If not, then I will see you at some point tomorrow. If you have any questions, please put them in the chat box. I'll be here for the next 9 minutes, and I will talk to you soon. Take care.